let me also welcome them. As you would be aware, we are today supposed to be dealing with the engagement of stakeholders on the amendment of
recording in progress.
Bill number 2 of 2021. We are engaging stakeholders, so there are a number of them that are going to make presentations. But before I proceed, I must also welcome the Minister and the team from the department. Welcome everybody, including those who might be interested to be part of the meeting. You are all welcome, and the meeting is declared officially open. We want to make it a tradition that we start our meetings on time and finish on time, by the way, with clear outcomes of a meeting. It must not just be a meeting for the sake of the meeting. We must be able to say, this is what we have achieved out of the meeting. So welcome, Minister, and maybe let me take apologies, Portfolio Committee Secretary, if there are any apologies.
Morning again, all members and everybody present in the meeting. Yes, there's apology from the Minister. She will be in the meeting, but at 10:30 she has a prior engagement, so she will leave the meeting at 10. I did see the Minister on the platform earlier. I don't see her now, but we're trying to get the Minister back on the platform. There's also an apology from Deputy Minister Bapela that has family commitments and wouldn't be able to attend the meeting. There's also an apology from the DG. She won't be able to attend the meeting due to prior commitments, and confirmed that Dr. Tao, the head of the Disaster Management Center, will be leading the delegation. Thank you, Chairperson.
Thank you. Any further apologies from members, if there are any, which might not have been formally tabled?
Good morning, Chairperson. I'm not apologizing to be out of the meeting, to be not in the meeting, but my stomach is running. I'll be on and off in bathroom, so just that's my apology.
Okay, noted, Honorable Member. With that done, I'm not sure now. There was an approach that said the department should be the first to speak because the minister might leave early. I hear that there's a person who is leading the delegation. Even if the minister is there, then would hand over to the minister to introduce. But if she's not there, then let's allow the official who has been delegated to lead the team to take over. Over to you. I am advised, maybe it's a message I should have said, our meetings from now on will start at 9, not at 9:30 in terms of our programs. So I want everybody to be ready for that. We have just adopted a program that said all our meetings starts at 9. Over to you, sir.
Good morning, Chair, honorable members, and our minister who has just joined the session, and all colleagues and stakeholders. Chair, I've noted that our minister has just joined, so I would request that you advise whether we could request our minister to introduce. My name is Mapaka Dao.
My advice is the minister should introduce even you and the discussion. Minister, welcome. I was just told that we could not locate the link. You are welcome. And
thank you very much.
Can I hand over to you, Honorable Minister?
Thank you very much, Chairperson, and members of the Portfolio Committee and the officials from Cooperative. And I think, let me say that we are happy to participate in this discussion. The presenter will be Dr. Dao, but I just thought I should say a few things, which he may not necessarily have in his presentation. One, the health department and other departments, but particularly the health department, is almost towards the end of amending its own regulations, which will assist it to manage the pandemic, because the reason the disaster management was used was because the health regulations could not do what was supposed to do. So once they've done that, so there'll be consultations and then they'll be able to take over. But for now, and I also want to say the amendments that I see seem to want to almost equate the disaster to the state of emergency in terms of how it's managed. And I don't think we should go that route, because the State of Emergency Act is there and it's managed almost in the same way as we're suggesting here, as the honorable member is suggesting. The disaster, even the courts have, the disasters that happen cannot always be foreseen. And no one had foreseen that we'll have this pandemic. So they will not always be foreseen. And also the speed with which they must be managed, because we don't know what kind of disaster will befall the country at any one time. So trying to shift the management of disasters to Parliament, I don't think it's necessarily would be an efficient way of doing it, because the processes of Parliament take time. And also, there are checks and balances. There is oversight by Parliament, even on the Disaster Management Act implementation. So as a department, we really do not agree with the amendments. But I will now introduce Dr. Dao, who is our leader in the Disaster Management Center. And he is our chief advisor when it comes to disaster management issues. And so over to Dr. Dao. Thank you.
Thank you very much, Minister. Once more, good morning, Honorable Chair, honorable members. all players in attendance. Just in line with the introduction and the position already articulated by our minister, just to also confirm that at technical level, we have done some consultations with our stakeholders, although we may not have covered all of them, but we did some sizable consultation on the text of the bill as a private member's bill. We have also done some international benchmarking on how disaster management is applied based on the need to secure the well-being of the people, but also sustaining development. And also we looked at case law in terms of dealing with disaster risk issues, particularly from an emergency response and recovery point of view. So the presentation that we have prepared under the guidance of our minister and the DG will articulate that text and conclude with the position as already pronounced by our minister. I will just, with your permission, Minister and Chair, request that Ms. Anne Brewer take us through the text, and then I will note key issues that might still need emphasis and also respond to some of the technical questions that will come. Thank you very much.
Good morning, Honourable Chairperson and Honourable Members and Minister. Thank you very much for the opportunity. May I proceed with the presentation?
Yes, proceed.
Thank you. I just want to confirm if you can see the slideshow.
Yes.
Okay. Thank you very much. Okay, so the purpose of this presentation is basically to provide the department's position on the Disaster Management Amendment Bill introduced in Parliament as a private member's bill. So I will not go through the memorandum on the objects of the bill. I think you have already discussed that previously, and you are aware of the intention of the bill. But it is basically also to contend that it is in a constitutional democracy, any legislation which has such severe consequences and which impacts all the citizens and their human rights should be subject to more legislative accountability and oversight. Notable, however, is that there is no reference to Section 36 of the Constitution in as far as it pertains to matters relating to emergency management. So this is just the memorandum on the objects of the bill as stated by the private member in terms of the reasons why there is a need to amend the Disaster Management Act. So basically, the bill seeks to amend the Disaster Management Act in terms of the duration of a state of disaster, also to provide that any actions taken as a result of a declaration of a disaster is only effective prospectively, and also provide that only the National Assembly, provincial legislature, or council of a municipality may resolve to extend a national, provincial, or local state of disaster. To also provide for the duration of the extension, and to further provide for the requisite majorities required in the National Assembly, provincial legislature, and council of the municipality in order to extend a national, provincial, or local state of disaster, respectively. It is also to amend the provisions dealing with the lapsing of a national, provincial, or local state of disaster, and determination of the regulations and bylaws made in terms of it, and to provide for other matters as well. So this is basically the areas that the bill seeks to amend. As the Minister has indicated in her introduction, the courts during 2020 and 21 in the De Beer, SL, Freedom Front Plus, Helen Suzman Foundation, and the Democratic Alliance case, amongst others, adjudicated on key aspects regarding the interpretation of the legislation, and specifically sections 27, 41, and 55 that deals with the state of disasters. These have detrimental consequences for the proposals put forward by the bill. Briefly, if I can just mention a few, the Helen Suzman Foundation case, in that case, the court held that Parliament properly delegated the regulation-making power in terms of disaster management to the executive, which fits into the broad constitutional scheme. In the Democratic Alliance case, the court held that since it is near impossible for Parliament to legislate in advance the ways and means to deal with sudden unforeseen calamities, it is best for it to delegate some of its legislative functions. It concluded that the executive is better placed to deal rapidly, effectively, and comprehensively with disasters in a way Parliament cannot do, especially if Parliament is not in session when a disaster strikes. The court also found that there is sufficient oversight mechanisms for Parliament to ensure that the Minister stays within the restraints imposed by the Disaster Management Act, both when making regulations and also when considering the extension of the national state of disaster. In the SL case, the court indicated that the construction of the Act makes perfect sense because it contemplates a situation of a national disaster where regulations have to be made to give effect to containment of the harm caused by a national disaster. The implementation thereof would invariably have to be brisk in circumstances where the declaration is not permanent. In the Freedom Front Plus case, the court held that the difference between regulation making and executive oversight is distinct. One of the roles of the National Assembly is to scrutinize and oversee executive action, and that the national state of disaster does not render this provision inoperable. It was also recognized that states of disaster cover a wide range of different circumstances, and that the Disaster Management Act does not permit deviation from the constitutional order, and therefore, unlike a state of emergency, does not suspend rights, but may temporarily limit rights within the provisions of Section 36 of the Constitution, when those limitations are a consequence of dealing with the effects of the disaster, as we have seen in dealing with COVID. So basically, having considered the proposals and the effect the bill may have on the disaster management function, and also looking at the court findings and other affirmative cases and their effect on the bill, the department provides the following position and response to the Portfolio Committee tasked with processing the bill. So now we look at a clause-by-clause analysis of the bill. And clause 1 of the proposed bill seeks to amend Section 27 of the Act, and indicating that a national state of disaster may be effective only prospectively and for no more than 21 days, unless the National Assembly resolves otherwise. It also says a minister may terminate a national state of disaster before it lapses, and that the copy of the notice declaring a state of disaster must be tabled in the National Assembly. It also provides that the National Assembly may disapprove of any regulations or directions made under such a declaration, or may make recommendations to the minister pertaining to such regulations and directions. The department basically believes the proposed amendments will significantly hamper the efficiency of taking action where needed, specifically to deal with it expeditiously to advance the objectives listed under sections 27 of the Act, which provide for the extraordinary measures during a state of disaster. It is also important to take note that a national state of disaster is already effective prospectively and is initially valid for 3 months, which experience has shown is most often required to bring about the required interventions. Where a shorter period is adequate, the minister may also terminate the national state of disaster. And where a longer period is needed, the minister may extend the national state of disaster, which has been the case with COVID. Limiting the initial period to 21 days as proposed in the bill would therefore be counterproductive in our view. The proposed change to reallocate this power to the National Assembly will negatively hamper such a decision, especially if the National Assembly is in recess. The minister, in terms of Section 27(5)(b) of the Disaster Management Act, may already terminate the national state of disaster before it lapses. The concept, therefore, of affording the National Assembly the power to extend the national state of disaster, but retain the minister's power to terminate the national state of disaster is therefore not rational. The proposed tabling of a copy of the notice declaring a national state of disaster in the National Assembly is supported only to the extent that it serves to promote oversight of the executive in terms of Section 55(2) of the Constitution. The amendment proposed to afford the National Assembly the power to disapprove any of the regulations or directions is therefore not supported, as it will negatively affect the speed at which the required regulations are to be made. What we can support is that the National Assembly, as part of its oversight of the executive, may make recommendations to the minister on the regulations or directions already issued by the minister, or that may be required whilst performing its oversight function. But we do not foresee that the minister should be bound by it. If we look at clause 2, the proposal is that regulations or directions to cease to be of force once the national state of disaster lapses, and the validity of anything done under or by virtue of any regulation or direction from the time of the declaration of the national state of the disaster to the time it lapses. So these amendments are also not recommended, as it is already implied by sections 27(3) of the Disaster Management Act, that once the basis no longer exists on which the decision has been made to declare a national state of disaster or to extend it, any regulations or directions made to deal with the disaster is no longer needed, and as such would cease to be in force. Similarly, any restrictions or powers afforded by the regulations only exist as long as the regulations and directions are enforced, prospectively from the date of its publication and to the date of the state of the disaster, when it lapses or is terminated. So the reasons put forward above for not supporting the allocation of power to the National Assembly to disapprove any of the regulations or directions is also applicable to this particular clause. When we look at clause 3, it talks about a provincial state of disaster and the powers of the Premier, and also the notice that must be tabled in the provincial legislature. So it is a similar provision than the previous one. It is just affecting the province and not the national or the National Assembly. So these amendments are also not recommended, as it also fundamentally shifts the responsibility to extend a provincial state of disaster and alters the process of making regulations and directions at the provincial level. The same reasons, therefore, for not supporting the amendments proposing clause 1 are therefore also applicable to this. And the same goes for this part that deals with the regulations and the validity. If we go to clause 5 is applicable to the local sphere of government, and therefore similar provisions are proposed. And once again, the amendments are not recommended, as it also fundamentally shifts responsibility to extend the local state of disaster and alters the process of making bylaws and directions. So for the same reasons, the national and provincial process is not supported. This clause applicable to local government is also not supported. If we move to clause 6, it talks about the bylaws or directions to seize and also the validity of anything done under by virtue of any regulation or direction from the time of the declaration of the local state of disaster to the time it lapses. And once again, these amendments are not recommended, and the same reasons for not supporting the previous amendments applicable to the province and national is not supported. If we look at the comparison of state of disaster and state of emergencies, we just need to quickly highlight the following. So there are two pieces of legislation, which is the Disaster Management Act and the State of Emergency Act. There is a constitutional limitation provided in terms of Section 36 of the Constitution, which relates to a state of disaster, whereas the Section 37 of the Constitution is applicable in the state of emergency. So if we look at the purpose of the Disaster Management Act, it provides for an integrated and coordinated disaster management policy that focuses on preventing or reducing the risk of disasters, mitigating the severity of disasters, emergency preparedness, rapid and effective response to disasters, and post-disaster recovery and rehabilitation. It also provides for the establishment and functioning of national, provincial, and municipal disaster management centers and disaster management volunteers and other matters. The state of emergency its purpose is to provide for the declaration of a state of emergency and to empower the president to make regulations in pursuance of any such declaration and to provide for mechanisms connected therewith. So there should be an understanding of the difference between the oversight mechanisms and regulatory mechanisms that becomes quite apparent. If we look at why a declaration of a state of disaster is necessary, it is where existing legislation and contingency arrangements do not adequately provide for the national executive to deal effectively with the disaster, or when other special circumstances warrant the declaration of a national state of disaster. In the case of a state of emergency, the declaration is necessary to restore peace and order when the life of the nation is under threat. So the declarations are quite different in a state of disaster and a state of emergency. If we look at the range of applicability, disasters may take many forms and can cover a wide range of circumstances, including floods, fires, COVID-19, of course, and many other disasters. When we look at the state of emergency, it is limited to the rest of circumstance where the life of the nation is under threat and is done particularly to restore peace and order. If we look at the authority of who may declare, in terms of a state of disaster, the minister to whom the administration of the act was designated by the president in terms of Section 3 has the authority to declare a state of disaster, whereas a state of emergency can only be declared by the president. In terms of the regulations, the minister, a premier, or a council may issue regulations, whereas in a state of emergency, the president can issue those regulations, but persons and bodies may be empowered to make orders, rules, and bylaws. The initial validity of a state of disaster is 3 months, whereas a state of emergency is 21 days. And the extension of a state of disaster is governed by the Act as well. And as indicated previously, it can be extended by the Minister for 1 month at a time by notice in the Government Gazette. In the case of a state of emergency, it may be extended for 3 months after debate in Parliament, and a 50% vote for first extension. The next extension requires 60% vote. And as you are aware, the initial validity is only 21 days. If we look at the termination of a state of disaster, it can be terminated by the Minister at any time by notice in the Government Gazette. And in terms of the state of emergency, the President may withdraw the proclamation at any time. During a state of disaster, regulations are made for assisting and protecting the public, providing relief to the public, protecting property, preventing or combating disruption, or dealing with the destructive and other effects of disasters. Whereas in the case of a state of emergency, restoring the purpose of regulations is for restoring peace and order and to make adequate provision for terminating the state of emergency or to deal with any circumstances which have arisen or are likely to arise as a result of the state of emergency. In the case of a state of disaster, there is no mechanism for this approval of regulations by Parliament, whereas in a state of emergency, it is. If we look at the cessation of regulations, upon the lapse of the national state of disaster, it ends. And then in the case of a state of emergency, it is upon withdrawal of the proclamation or resolution by the National Assembly to not extend the state of emergency or disapproval of regulations made by the National Assembly. The important difference also in terms of the limitation or derogation of rights, in terms of the state of disaster, it is subject to Section 36 of the Constitution, whereas in the case of a state of emergency, derogation of rights are subject to Section 37 of the Constitution. So if we lastly look at the recourse in terms of infringement of rights, so state of disaster, it does not affect anybody's fundamental human rights infringed in the Bill of Rights. The victims of infringements of those rights retain all their remedies against the perpetrators. Whereas in the state of emergency, the state may suspend most of the provisions of the Bill of Rights. The victims of any infringements of the suspended fundamental rights do not have any recourse against the perpetrators. So based on these differences, the DCOC is of the view that there is no justification for making states of disaster subject to the same rules as that of states of emergency. If we look at the parliamentary oversight proposals, we can see Section 42 and 55, 92 and 102 of the Constitution provide for parliamentary oversight of the executive. No more is required for the exercise of efficient oversight by the National Assembly over the declaration of a state of disaster and also the regulations made under it. The efficiency of the parliamentary oversight, however, depends on the mechanisms created by the rules of the National Assembly and the efficiency of the implementation of those mechanisms. But it is already adequately provided for. The changes proposed in the bill will affect the efficiency at which the required regulations to deal with a disaster is implemented. So if the mechanisms for parliamentary oversight applicable to states of emergency were to be made applicable to states of disaster, they would impose the following additional burdens on the national executive. They would have to mobilize National Assembly to approve extensions of a state of disaster within the first 21 days and thereafter every 90 days. The National Assembly may only approve such an extension after a public debate. After the first extension, any further extension may only be approved by a 60% majority. The National Executive would also have to defend disaster regulations whenever challenged in the National Assembly to avoid their veto. So it can become a very complicated process. So in conclusion, the department maintains its view that the minister, a premier, and a council is sufficiently empowered by sections 27, 41, and 55 of the Act to make regulations and directions. We also believe the courts have found that the assignment of these functions is constitutional, functional, and that sufficient mechanisms exist in the Act, also in the Constitution, and within other legislation, for example, PAIA and PAIA, and with the structures of Parliament, provincial legislatures, and councils to perform adequate oversight on the work of the executive. These structures should continue with its ordinary functions to scrutinize the executive's application of its delegated powers to help ensure that legislative measures implemented are in line with the rule of law. The DCOC therefore restates its view that the proposed amendments will significantly hamper the efficiency of taking action when needed expeditiously to advance the objectives listed under Section 27 of the Act. Experience has also shown it is most often required in the initial phases of the disaster to bring about the required interventions. In this regard, the existing 3-month initial validity period of a state of disaster enables the executive and the administration to focus its attention on the immediate relief and rehabilitation efforts. How these aspects are to be implemented using regulations and directives, and to obtain the information needed to brief Parliament. So where this can be achieved within the existing legislation, the minister may simply terminate the national state of disaster or allow it to lapse. And where a longer period is needed, the minister may extend the national state of disaster. The proposed changes to limit the initial period to less than the current validity period and to reallocate the power to extend the national disaster to the National Assembly will hamper service delivery, especially if the National Assembly is in recess or divergent views emerge. The concept of affording the National Assembly the power to extend the national state of disaster but retain the minister's power to terminate the national state of disaster must also be considered, as it is not rational that the one function is allocated to the executive, but the other is allocated to Parliament. In terms of constitutionality, the various courts have confirmed, and the legal opinion obtained by the department also indicate clearly that the courts agree that the minister, in as far as the regulations is concerned, not only acted within the legal framework set out by the Act, but that the minister also, by and large, applied these concepts reasonably and rationally to achieve an identifiable purpose in the least intrusive way and to be functional for the shortest period of time needed. It is also notable that the broad limitations the minister, as the administrator of the Disaster Management Act, imposed as a result of the COVID-19 pandemic is exceptional, and therefore it must be considered that other risks that may lead to a national state of disaster being declared may not need such broad means be instituted over such a long period of time, and taking into consideration that the Disaster Management Act is applicable to various kinds of disaster situations. The bill in its current format seeks to alter this system in a way that may be counterproductive and hamper the speed and efficiency with which a disaster should be managed. So, taking into consideration all of this, it is recommended that the Portfolio Committee does not support the bill. Thank you.
Honorable Minister, you did introduce the speaker and she has presented. I'm not sure if you want to say anything before I know you have to be excused.
And thank you very much, Chair. No, I think she's presented, and that's our collective view, that we do not, we asking the Portfolio Committee not to support this bill for those reasons. Thank you.
Thank you. Honorable members, I was saying, normally after every presentation, you ask questions for clarity, and we take those. And but otherwise, we're not getting into the discussions as yet. I see two hands, Honorable Teza and Honorable Brink. Can I take you, Honorable Teza?
No, thank you very much, Chairperson. Question of clarity. The first one that I would ask is, how does this proposed amendments link with the losses that capitalists have experienced during the lockdown period from March 2020 to date? Because I assume that we've heard this before in the committee, that we even were in loggerheads with some people who came without showing no transformative ability or willingness from the tourist departments. And we even asked about the emerging SMMEs, what they do and things like that. So I'm asking this question. And the second concern is, how do these amendments seek to correct the fact that the army was sent to defenseless people, resulting in some people being killed, Chairperson, in terms of the enforcement of the lockdown regulations and the seemingly reactive nature of the Disaster Management Center in terms of preparedness and assisting at the center, assisting and protecting the public rather than killing it. Those are my two questions, because I don't want everything else to disappear. Thank you very much.
Honorable Brink.
But Chairperson, I have noted the need for the Minister to leave the meeting earlier, but perhaps that in itself illustrates a problem that there is with the current legislative framework. So we have the National Minister here making a presentation and giving policy statements on the government's approach to a national state of disaster. But she's also able to leave early, and us as elected representatives are not able then to engage the minister directly on those policy statements as to get some concrete feedback. So, Chairperson, I wonder if we can't use this opportunity while the minister is available, just as members, to engage on this presentation, because the minister can give valuable input, and I think there are very pertinent questions that arise from the presentation that has just been made.
I agree. Let's engage. I think she suggested around 10:30 that she would leave. I assume the minister will listen as well. Let's do that.
Thank you, Chairperson. Can I then proceed just to make a few points?
Yes.
Chairperson, this is my problem with the presentation and the policy statements by the mayor, by the minister, not the mayor. Apologies. All of the differences that were pointed out between a national state of disaster and a national state of emergency, especially by Dr. Brever, are interesting, but they are less relevant than the similarities. And the point that under a state of emergency, there are significant procedural constraints to the exercise of executive power, while under a national state of disaster, where the executive enjoys similar powers, there are no significant procedural constraints to the exercise of that power. That is the main point. Why legislation and proposals for reform say, let's do what we did with the state of emergency. Let's apply those procedural constraints to state power, to a state of disaster. And I think that point is missed. So here is the bigger problem, also not addressed by the presentation. Firstly, what constitutes a national state of disaster is very poorly defined in the existing legislation, and it amounts more or less to a discretion by a single office bearer, who is the National Minister of Cooperative. So under Section 27, that very same office bearer who decides what is a national state of disaster then obtains, by virtue of that declaration, powers that are usually reserved for Parliament to make regulations and to issue directions over vast swathes of ordinary life, and also to delegate that power to other people. That same office bearer, the Cooperative Minister, and it's really not about who the current minister is, it is about a single executive office, is also then the only person capable of extending a national state of disaster or allowing it to lapse without consulting anybody. The problem is not necessarily the delegation of these powers by Parliament in the legislation to the executive. It is the fact that Parliament completely loses the ability to recall the delegation or to exercise significant checks and balances on the exercise of this power, at least under the Act as it now stands. So unlike a state of emergency, which is similar in the power that it grants the executive to a national state of disaster, Parliament has no power to recall or to amend regulations issued under this state. Parliament has no power to question whether the state should be extended. Parliament has got no formal role to make amendments to regulations issued under the state. It can only make suggestions by member statements or in a committee such as this. And there is no real substantive obligation on the minister to even respond. So, Chairperson, the concentration of power and the lack of accountability that is inherent in the structure of the Disaster Management Act as it currently stands is not only a risk to freedoms and to the legislative competency of Parliament, it also leads to irrational and unreasonable decisions. People have to take government to court to find out what the scientific evidence is of certain restrictions, and that costs a great deal of money. So yes, people have that recourse, but at what price? Not only to the pockets of those that have to litigate, but also to the freedoms of ordinary people. Most South Africans don't have the power to go to court and litigate. And that is true of many of the restrictions that were applied under the COVID-19 lockdown. And so, Chairperson, the point is not that disaster management powers should be exercised by Parliament. And that is not what this bill, on my reading, even suggests. That is not the point. Parliament should not be the manager of disasters. The point is that the power of the executive should be constrained by the only body that represents ordinary people, and that is Parliament. So Parliament shouldn't be the manager of disasters. Parliament should at least have a role in constraining the existing power of the executive to manage disasters and not to abuse those disasters. So Dr. Brewer mentioned that the courts have already decided, they've already interpreted this. But Chairperson, that's only partially true because the Constitutional Court has not had the opportunity to determine the constitutionality of especially Section 27. And one of the cases that Dr. Brewer mentioned, the Democratic Alliance case, is currently before the Constitutional Court. So it is not entirely accurate to say that this matter has been decided by the courts. And so that point should also not be accepted without further scrutiny. The second point in regards to, or the third point in regards to the role of Parliament is that even if Parliament is in recess, it can be called on to reconvene on an emergency basis. If this can happen under a state of emergency, why can it not happen under a state of disaster? And so that argument also does not make sense. So in essence, Chairperson, what we are talking about here is not taking away any powers from government, simply constraining those powers by making them subject to the proper oversight of Parliament. And in that way, we make sure that the public also know what the regulations are, and they can have input, even on an abridged basis, on what those regulations should be. And I would dearly like the Minister and Dr. Brewer to answer to these points. Thanks very much.
Thank you. I don't seem to see any other hand. I will hand over.
Follow up. Sorry.
Honorable Cesar, yes. Are you
Thank
following up now? How do you follow
I'm not following up, Chair. I left something, please.
Oh, okay.
Please, I'm not following up. Chair, sorry about that. That is for the opportunity. That's
Yes.
Yes. So I just want to ask a question to the Minister in terms of the decisions that have been made with regards to the regulations that were issued out during COVID-19, just from a perspective of any sector, including the religious sector, any sector, in terms of its operation, whether there was scientific evidence or empirical, they were based on scientific evidence or empirical observation at the time, whether you observe and assume that this is the case, and therefore you issue out the regulations. What were they based on? Just for clarity, on empirical observation or scientific evidence in terms of taking those decisions. The second one pertains to this thing of section, I think it's, just hang on, of section 8 of the Act, which actually sets out. I just want to ask the status of the NDMC on in terms of reining upon, because some departments really do not. If we call the Disaster Management Center, rightfully they respond at all times, but you find people that are sleeping at work. They don't even know a road within a municipality that has been turned into a river due to the disaster that has happened, particularly as it relates to the rains. it says there that both section, I think it's section 8 and section 9 and section 10, which puts it as an institution within the public service. What are its powers to then make the whole value chain functional in terms of what should happen within the disaster period? And then the very last one, again, Chair, is what measurement actions are in place to just get a sense of the early warning signs or even drills that are done for preparedness. I often hear this thing of we are not prepared. We can't anticipate. We can't do anything. It's like a celestial thing that just happens, and so we must not be prepared because it's going to get to this thing of the fire in Parliament that just erupted, and then there were no measures to actually see it coming. So I just want to ask that for interest's sake. Thank you very much.
Thank you, Honorable Minister and team.
Thank you very much, honorable members. I will ask Dr. Tao to respond to some of the issues, and then I'll respond to the rest. Thank you.
Thank you very much, Minister, Chair, and honorable members. Yes, I will respond to some of these technical issues. I'll start off with the issues raised by Honorable Brink without going into the merit of the issues, but just to say that this is, perhaps we should always just be mindful that this is a piece of legislation that Parliament, in its wisdom and also considering international best practices, felt it to be suitable for managing risk, especially where you would like to infuse risk reduction in development, and also where you would like to respond speedily when you are faced with emergencies, by ensuring the separation of powers and that oversight and accountability continues to be entrenched as the section of the Constitution that we have cited. It will also assist if we just read the sections regarding declaration with section 26 of the Act, which in the case of a national state of disaster empowers the Minister for Cooperative Governance and under the aegis of the National Executive to coordinate. That means they are empowered to make decisions that are meant to ensure that we save life, protect the public, and that those decisions must be made in a speedy manner so that there are no, further damages as a result of any hazards that might be prevailing. So you can just use an example where I am involved in an accident. There has to be various processes before I can be lifted or something can be done to save an individual. So while COVID was a new experience to all of us that required innovation, but what we can assure honorable members is that all decisions from the technical point of view, we ensure that we follow the three principles of rationality, reasonableness, and procedural fairness in making those decisions and within the framework of the Disaster Management Act. So read in totality, we are able to see how government has balanced decisions. Hence, most of the the court cases have confirmed decisions that were made by the National Executive. Then the second matter relates to the questions raised by Honorable Tessa, whether decisions were based on empirical and scientific evidence. Yes, I can indeed confirm that decisions were based on the needs and to continue augmenting the contingency arrangements and other legislation that was utilized to manage COVID, sectoral legislation that were also utilized. Hence, we saw directions being implemented by, adopted and implemented by various sectors as mandated by the regulations that have been issued. So there was a question also from Honorable Tessa about Section 8 of the Disaster Management Act. The section, as per the amendment of the Disaster Management Act in 2015, provides that a National Disaster Management Center is established as an institution within the public service. And I think the Honorable Member also made reference to Section 9, which just outlines the purpose of the NDMC, and also Section 10, that state that a person appointed as head of the National Center reports to the Minister and holds office in terms of conditions set out in the written employment contract. I must say, Honorable Members, that the issue of the institutional form and location of the National Disaster Management Center, it's a matter that is receiving attention under the guidance of our principals, and it's an issue that we will, in due course, support our Minister to update Parliament on, to ensure that the National Center indeed is an institution within the public service and we can improve agility and effectiveness. So that is how I can respond to this. The last one is the issue of drills and for preparedness. Yes, we have a very watertight system in terms of preparedness. We work from the basis that every season in the country brings with it various risks. Whether it's a winter season or it's a summer season, we know that there are various hazards that will occur. In around 2014, we did what we call the National Indicative Risk Profile, that is pointing to areas that are susceptible to certain hazards. And then as a result of that 2014 risk profile, which we continue to update on a regular basis, we receive forecasts, weather forecasts and climate outlook from the South African Weather Service. So once we receive the forecast, we then analyze it in terms of our indicative risk profile and also the short-term focus for different areas. And then we come up with seasonal contingency plans. Seasonal contingency plans are informed by submissions from all municipalities and all provinces on the hazards that they expect, the readiness measures that they've put in place, stockpiles and their awareness that they are rolling out. And then we activate teams and brief our principals as to what is expected for the season, which areas are likely to be impacted, and then the drills or preparedness measures that are put in place that we activate prior to and also during occurrences. That has been happening for a long time, but obviously we have challenges of infrastructure that is built in areas that are not suitable. But as you can see, Weather Service continues to communicate. We also have what we call the Common Alert Protocol with the South African Weather Service, through which once we receive alerts or warnings, we distribute to our different stakeholders. We also undertake training in terms of what we call the impact-based early warning system. Just now, as we are seated early this morning, we are monitoring one of the tropical storms, which are part of the seasonal occurrences in the Indian Ocean, and the other one that is developing, which are not yet a threat for South Africa, but this is just to show the extent to which we are having all our tentacles on the ground to make sure that we observe the situation and can respond effectively. Yes, we still have challenges in that municipal centers, provincial centers do not account directly to the national center, and therefore we achieve a lot through persuasion, and we hope that in future, once the system has been reformed, we might have a system in terms of which our working protocols and accounting responsibilities and channels have been streamlined. Thank you very much, Honorable Minister, Chair, and honorable members.
Thank you, Dr. Dow. First, let me just remind honorable members that it is not correct to say that there is only one minister who deals with the national state of disaster, who does everything as an individual. That's not correct, and we all know it. If I may quote from the Disaster Management Act itself, Section 26 says responsibilities in event of national disaster. Then Section 1 says the national executive is primarily responsible for the coordination and management of national disasters, irrespective of whether a national state of disaster has been declared in terms of Section 27. So it's the executive as a whole that is managing the national state of disaster, not an individual minister. And that's why the president established the NCCC, and then the NCCC also, because the Disaster Management Act requires that we also work with the provinces. That's why there are no major decisions that are taken without going to the PCC, which is the Presidential Coordinating Committee, which has the premiers, the MECs of COGTA, and traditional leadership. It has the metro mayors, and anything that the president announces starts there. From the NCCC, it goes there. Then from there, it goes to cabinet, because the law says it's the executive that manages. It doesn't say it's one minister. It goes to cabinet. Then when cabinet has taken a decision, obviously cabinet, not all the cabinet members can sign a gazette. So it then goes to us, but we don't make the decisions. It's the executive, because that's what the law says. So I just wanted to clarify that again. I've clarified it many times, even in the portfolio committee, but I thought I should clarify it again, because it is disingenuous to say there's only one minister who just wakes up, decides, wakes up, says, wakes up. It's not true. And then on the question of the security forces, I think our security forces act in the best way they can, whether there is a national state of disaster or not. And if things happen that are not right, it's not because of the state of disaster. I don't think it's whatever may have happened is not happening because specifically it was the national state of disaster. There are laws that allow the police to get the defense force to work with them. And in applying those laws, the relevant institutions must then make sure that they are applied and they look after the population. So I think whatever may have happened then may have been obviously that matter was dealt with, but I don't think it was also not a general occurrence. On the whole, the security measures that were taken did not kill people. It wasn't a general occurrence, but it was regrettable and unfortunate that it did occur. And of course, I didn't quite get the issue on small business, what the question was around small business.
Can I repeat it? Sorry, Chair.
I don't know whether that. Can I finish, Honorable Member?
Yes, yes.
Honorable Member.
Sorry, Chair.
I don't know.
Minister, proceed.
I don't know whether the chair will allow the honorable member to repeat that particular question.
No, I will not allow it. Proceed, Minister, to finish.
Okay. So I just think that the national state of disaster also, in this particular instance, we must also remember that this was the first time this government or any other government in this country in the past century had actually had to deal with a pandemic of this nature. And as Dr. Dow says, that the decisions that were taken within the available information, the available evidence, because the whole world was grappling with this pandemic as a new experience. And also, some of the decisions were taken based on experiences that had been studied elsewhere, and also the advisory committee that was advising the Minister of Health. An example was made of the religious sector. And if you recall, there was a case that was reported widely internationally of a situation in church where there had been a super spreader. But also we saw earlier on in the pandemic here in South Africa, what had happened in the Free State. But as I say, we were learning as we were going along, because it's not something that you say, hey, there was lots of information and experience in the world or in the country. So yes, it was based on what we had and what we could glean from the rest of the world that was experiencing the same thing, but also some lessons from the Spanish flu, because there were lessons that we could learn there as well from what had happened during the Spanish flu. And in fact, if you will see if you go back to what had happened during the Spanish flu in South Africa in particular, you can see that it was more disastrous than now. And of course, we can't blame them because they also were dealing with a new experience, but they lost lots of people within a short space of time, much more than South Africa has lost in 2 years. There was even a time called Black October, where they lost hundreds of thousands of people at that time. So that's what I can say, Chair. Thank you very much.
Thank you. Honorable members, I understand that would want to engage with the minister, but we have invited stakeholders. I think we must be, we can't get answers for everything. So I would suggest, because of time and the fact that we are managing our time and we have invited stakeholders to engage, to now allow the minister release if there's anything, Honorable Teza, you would have wanted. I think the officials would be sufficient to deal with that. If not now, then the minister might find time to talk to that at some other time. I think it was specific, you were talking about small business. I'm sure in the general response, that might have been covered. If not, I think it will be covered in the future. Thank you very much, Honorable Minister. We are not releasing your team because they must listen to what the other stakeholders are going to do. Let's now move, honorable members, and we start with the first stakeholder. When I say first, doesn't mean that this presentation was not part of that. Agri South Africa, represented by Mr. Symington. Can we now allow you, I think we'll allow each stakeholder 15 minutes to make up their presentation. If it is less, we'll be very happy, but 15 minutes. Agri South Africa.
Good morning, Chair. Good morning, everybody.
Yes.
Thank you for the privilege to be part of this proceedings of this committee. My colleague is Andrea Kamfer. I would like to ask you if she can make a presentation, and then I will conclude with a few concluding remarks.
Yes.
Thank you, Chair.
Thank you, Chairperson. Good morning, honourable members. My name is Andrea Kamfer. I'm the Risk and Disaster Manager at Agri SA. Chair, can I share my presentation?
Yes, please.
Perfect. Can you all see it?
Yes, can see it.
We just want to first start off by saying that we have heard that there's a lot of debates around the COVID-19 pandemic specifically. And we as the agricultural sector also wants to highlight that there's other disasters that the members should also take notice of, or that they already know, is agricultural droughts, floods, also other human-made disasters. So we just don't want to focus on the COVID-19 disaster itself. We also just want to give a high-level feedback. It's not going to be be more than 10 minutes. We didn't comment on every section of the amendment bill, but only those parts that's applicable. So Agri SA is the largest federation of agricultural organizations in South Africa, and through our membership, we represent a variety of farmers, from emerging small scale to commercial farmers. We've got 3 chambers, our provincial, corporate and commodity organizations. We represent also 26 commodity organizations and 56 corporate members throughout the agricultural value chain. The Risk and Disaster Unit specifically aims to support government's efforts in mitigating the severity of disasters and emergency preparedness. We have a good sustainable relationships with the Department of Agriculture's Directorate on Climate Change and Disaster Management, as well as the National Disaster Management Center, to ensure that there's proper risk reduction and resilience practices are being applied within the agricultural sector so that we can effectively manage disasters. We have some general comments on this amendment bill. Firstly, we agree that the disaster management is a multidisciplinary and sectoral function which powers and functions lie within all spheres of government, from provincial to or district, provincial and national. The Constitution of South Africa safeguards disaster management as a responsibility by the government to protect from and manage disaster occurrences through the principle of cooperative governance. For purposes of Agri-SA's commentary, it's notable to distinguish between a state of emergency as defined by the Constitution, as well as a national state of disaster as defined by the Disaster Management Act. The NDMC has earlier alluded on this point specifically, and with the COVID pandemic has placed the Disaster Management Act under severe scrutiny as the overlying functions and authorities have been bestowed upon the Department of Cooperative Governance and traditional affairs to manage the disaster. Just some of the clauses that we are describing or giving comment on is Section 2.2 of the Disaster Management Act provides that the Minister may, in consultation with Cabinet members, who is responsible for the administration of national legislation, as referred to in subsection 1b, issue guidelines on the application of that subsection. Agri-SA is of the view that when a national disaster, either natural or human-induced, are declared, the management, and that's the executive and legislative powers, including those of the NDMC, should be bestowed upon the Office of the President, as it has cross-cutting delegation authorities to ensure integrated and multi-sectoral and multidisciplinary management as envisioned by the Disaster Management Act and its framework. The Disaster Management Center, which is established in terms of Section 8 of the Disaster Management Act, should in assessments of disasters have direct reporting to the Minister of Cooperative. That's currently the situation. While the Disaster Management Act, in Agri-SA's view, does not currently provide adequate accountability, Agri-SA is of the view that when national disasters, even natural or human-induced, are declared, the management, including those of the NDMC, should be bestowed upon the Office as the President, as I've alluded, as it has integrated and multidisciplinary management functions. Should coordination of these functions of government departments and administrations fall within the ambit of the President's executive authority, it will fast-track decision-making and improve disaster risk management planning and implementation. Then the proposed amendment to sections 27.5b, 41.5 and 55 of the Disaster Management Amendment Bill, of the draft amendment bill, provides that a national state of disaster may only be effective for no more than 21 days from the date of the declaration, unless the National Assembly resolves to extend the national state of disaster. Agri-SA is of the opinion from the outset that the provision is aligned with a state of emergency as envisioned in Section 38 of the Constitution. And as I also said earlier, there's a distinctive difference between the management of these declarations in the application by law. It's two different laws that governs the procedures. The National Assembly, Provincial Legislature and the Council of a Municipality should also be in position to call for a special meeting to extend the disaster declaration if need be. It's also a time-use process if it has to go through these three legislative positions or assemblies. The disaster declaration is also a time-use process as officials need to gather information to conduct assessments on the extent of the severity of the risk, especially with regard to the agricultural sector. Lastly, what we a general comment from Agri-SA is that we are of the opinion that 21 days, given practical experience on drought declarations, are insufficient to manage the national state of disaster. Declaring a national state of disaster follows a bottom-up approach, which means that the local state of disaster should first be declared on district level, thereafter provincial, and then a national state of disaster by the NDMC. The NDMC, after due considerate investigation, declare then, like I said, a national state of disaster. And Agri-SA has noted the process of obtaining information from various departments And that would be the Department of Agriculture, the provincial disaster management centers, from a grassroots level up to national, considering budget allocation, reprioritizing of budgets, and subsequently seek funding from national treasury will in most cases not be concluded within 21 days. So Agri-SA proposes that the period of 3 months for a disaster declaration should not be amended. That is the comment. I would like to ask if my colleague, Mr. Willem Symington, who is our chairperson for Natural Resources Centre of Excellence, if he also wants to give concluding remarks. Thank you.
Can I proceed, Chair?
Yes.
Thank you for the opportunity. I first want to make use of this opportunity from IKSA side to especially thank Dr. Tao from the NDMC for the way in which he accommodates us and as always has an open ear for the agricultural sector. As my colleague has stated, the main focus of this portfolio meeting seems to be the national state declared because of COVID. But the Act also, as he mentioned, the Act also provides for declaration of disasters and mitigating of other disasters. Without trying to lessen the effect of COVID, I think our focus at this stage is just where they're applicable to natural disasters and climatic disasters such as droughts and floods, like plagues and things like that. I would just like to make a few general comments, but maybe I should state my bona fides for the Minister firstly. I'm a teetotaler and I'm a non-smoker. So, Minister, be assured I've got no hidden agendas in taking part in this meeting this morning. That aside, it was mentioned, I think, by Dr. Tao or one of the other participants. I think that if I may make some general broadest comments, I think that in the implementation of the Act, or to implement the Act correctly, the objectives of the Act and the criteria by which declarations be made should be more clear-cut. There should be more definite strategies and plans in place so that one doesn't have to deal with subjective opinions when one declares a declaration. Maybe in the regulations or the implementation of the Act, there is still scope for more objective measurements of when and where a disaster declaration is necessary. Dr. Tao also mentioned the accountability, and this is one place that I do think that there is room for improvement on the 3 tiers of government. COCA is such a department that deals with so many issues in corporate governance, and one sometimes get the feeling that, especially on the municipal level and the provincial level, it is not always as if disaster management is fully capacitated. You mentioned that there is a thought going around that maybe one should have the accountability and the oversight of the municipal and provincial disaster management move a little bit closer towards the NDMC and national level to try and provide better capacity on the places where the disasters occur. Then in conclusion, I would just like to once again thank the Portfolio Committee for this opportunity and assure the Portfolio Committee that from IKSA's side, there will always be the commitment to assist wherever government needs us, not only for the benefit of our members or for the benefit of the agricultural sector, but our main objective is to assist government in the betterment of this actions that government has to undertake to the benefit of all the inhabitants of our country. I thank you, Chair.
Thank you very much. And that concludes that first presentation. We go to the next one. National Employee Association.
Good morning. Can
Good
everyone
morning.
hear me?
Yes, I can hear you.
Fantastic. Fantastic. Thank you very much, Committee Chairperson. I would just like to make a correction there. That is the National Employers Association of South Africa, not Employee Association of South Africa. My name is Rona Bakker, and I am the Senior Policy Advisor of NEASA. Thank you very much to the Portfolio Committee for this opportunity to present our oral submissions on the Disaster Management Amendment Bill. Thank you, Chairperson, and good morning to all the stakeholders participating in today's meeting. I'm going to start with just a short introduction to NEASA. As I said, the National Employers Association of South Africa is an employer representative body. We have approximately 10,000 members, SMEs, business owners, over all sectors of business in South Africa. And we like to voice their concerns, and their concerns will be addressed in this submission as well. On 30 January 2020, the Director General of the World Health Organization declared the novel coronavirus outbreak a public health emergency of international concern. That is, of course, the WHO's highest level of alarm. There's no need to explain to any person that this has been an extremely tragic, disruptive, and devastating pandemic, which shook the world and brought most people and their countries' economies to their proverbial knees. The true and possibly lasting effect of the pandemic, unfortunately, lies not only in the heartbreaking loss of life internationally, but also in the disastrous consequences of the economic lockdowns and their respective regulations. The National Employers Association of South Africa, NEASA, is of the opinion that the disease and pandemic itself did not and will never cause as much damage to this country as the executive leaders have done through the irrational, ineffective, and arbitrary regulatory response to this disaster by virtue of the Disaster Management Act. Following the announcement of the global pandemic, the South African Minister of Cooperative Governance and Traditional Affairs declared a national state of disaster in terms of Section 27 of the DMA. Various sets of regulations were consequently published following said declaration, which imposed the national lockdown. The national state of disaster, in conjunction with the accompanying regulations, had severe consequences and an adverse impact on the lives of every single citizen of South Africa. Citizens' fundamental rights were restricted, and certain activities and actions were completely prohibited. The economic repercussions were catastrophic, and millions lost their jobs. The Disaster Management Act does not currently provide adequate legislative accountability and oversight over the regulations published in terms thereof, the duration of the state of the disaster, nor in respect of the extension of the state of disaster. This potential room left through the Act's inadequacies for the executive to outrightly abuse their legislative and regulatory power is both unbelievably arbitrary and dangerous. In a constitutional democracy such as our own, any legislation which has such severe consequences and grants such unfettered powers, and which impacts all the citizens and their human rights to this incredible extent, must be subjected to absolute legislative accountability and oversight. I will argue on NEASA's behalf today, during this submission, that there is no choice but to implement this bill in order to ensure that the destruction caused by the executive disaster state will never occur in this country again. NEASA strongly, therefore, supports the passing and adoption of the proposed amendments to the Disaster Management Act. In terms of the current provisions of the Act, specifically Section 27, the Minister is given extensive legislative and regulatory decision-making powers. So extensive, NEASA believes, that the executive is given free rein and consequently was able to cause more irreparable harm during the COVID-19 pandemic than the actual pandemic itself. Therefore, the limitations to be placed on the extensive power of the Minister, the supporting executive, and any so-called advisory council by means of this bill is of inescapable importance. According to Section 27.5a, a national state of disaster which has been declared in terms of subsection 1 lapses 3 months after it has been declared, unless terminated or extended by the minister. Despite the state of disaster originally being set to lapse on 15 June 2020 as per Section 27.5c of the DMA, the minister and the executive exercised their powers and extended the state of disaster on a monthly basis every month for the past 22 months. It should be noted that Parliament had no oversight over this extension, nor did the National Assembly have any input or method of participation in either the extension of the state or of the disaster, or any of the accompanying regulations issued in terms thereof. I'd like to remind stakeholders and the Portfolio Committee that the purpose of the lockdown and the regulations initially were to allow the health sector time to prepare in order to efficiently and sufficiently deal with and mitigate the effects of the pandemic, and also the spread of the virus. Despite this not realizing at all, the irrational restrictions continue to strip people of their basic and fundamental rights, including restrictions on movement, gathering for religious purposes, bans on exercise, bans on the consumption of alcohol or purchasing of tobacco products, and worst of all, restricting the right to work and earn a living. Apart from the health sector not having been able to effectively prepare to handle the pandemic, the state not sufficiently supporting the sector financially or through infrastructure expansion, and thus rendering the lockdown and restrictions for that exact purpose useless and ineffective. The restrictions through the regulations did succeed in causing the following: economic destruction to be suffered by every South African for years to come, except, of course, the untouched politicians who enforced it. The decision to implement social distancing measures and limiting non-essential business has had an enormous impact on South Africa's economy. The lockdown forced a reduction in production and a slowdown in non-essential business. It impacted household spending patterns, while the disruption to global production and supply chains and the effect of uncertainty on the commercial environment and financial markets have aggravated the combined negative effect on the economy. Another thing caused by the regulations and restrictions and the lockdown was a record spike in job losses and unemployment. South Africa's unemployment rate rose to 34.4% in the second quarter of 2021 from the previous 32.6%. It was the highest unemployment rate since comparable data began in 2008, amid the worsening pandemic crisis, and this was also reflected in a week of deadly unrest and looting during July 2021 in parts of South Africa. During the second quarter of 2021, the number of unemployed persons increased by 584,000 to a total of 7.8 million. The number of employed persons fell by 54,000 to 14.9 million, and the labor force rose to 22.8 million. Job losses were concentrated in the financial sector, followed by community and social services and manufacturing. The expanded definition of unemployment, including the people who have stopped looking for work, was at 44.4%, up from the 43.2% in the prior period. The youth unemployment rate, measuring job seekers between the ages of 15 and 24 years old, hit a new record high of 64.4%. The regulations further caused massive increases in government debt, something South Africa can ill afford. Our country has suffered from flattened economic growth for the past 5 years, averaging at a 1.5% per annum. In February 2020, government committed to combating government debt and decreasing public spending. However, this commitment is now severely constrained, given the government's disproportionate response to the pandemic, which resulted in the gross loan debt increasing sharply by 20.7% year on year to a current 3.93 trillion rands, which of course represents 78.8% of our GDP. Furthermore, the lockdown, by means of the Disaster Management Act, caused the destabilization of security and safety in the country because of the lockdown-induced violent looting. The socio-economic consequences of the pandemic are likely to aggravate existing security concerns in the country, specifically civil unrest and crime. Allegations of corruption in the distribution of government relief funds are also likely to prompt the further public protest in the coming years, while the impact on unemployment will place additional pressure on the government's social grant system. Notwithstanding the evidently negative reaction of the South African public to the extended lockdown and accompanying regulations, South Africa continued for months on end to hopscotch between the various levels, with regulations and restrictions being amended ever so often, with no clear logic or rationale. The complete loss of trust in a non-transparent, unaccountable, and omnipotent government was caused by the lockdown and the regulations. The decisions that were taken by bureaucrats and politicians who do not forfeit a single benefit through the imposition of these measures. We can only speculate on what the anti-COVID measures would have looked like if the pockets of government officials had been directly affected thereby. There has been a veneer-thin rationale behind the majority of the regulations and restrictions as issued by means of the DMA. However, that is what decisions would look like when they are made by those who enjoy the benefits of our taxes without appreciating the agony and persistent toil of the private sector from where the taxes originate. The harshness and the disrespect of the regulations and restrictions towards entrepreneurs, as well as the lack of sound judgment by many of those who enforce these COVID regulations, testify of a lack of appreciation for the role these entrepreneurs play in keeping our society intact. Broadly, this bill proposes that only the National Assembly, a provincial legislature or municipal council, may implement a national, provincial, or local state of disaster or extend its duration. Additionally, any resolution to implement or extend the state of disaster, be it national, provincial, or local, can only be enforced following public debate in the applicable public representatives chamber. Oversight for either a national or provincial state of disaster will come from, in the case of the NA, the Portfolio Committee on Cooperative Governance and Traditional Affairs, and whichever provincial executive committee is tasked accordingly. The objectives are therefore, through the amendment of the DMA, to limit the arbitrary and extensive power of the minister and the executive by curbing the duration and declaration extension powers of the minister, as well as subjecting his or her regulatory or legislative decisions to parliamentary or legislative oversight and public debate in the appropriate forum. These amendments, as proposed, will ensure that the state of disaster as declared by the minister is only declared for 21 days initially, or extended only if the relevant legislature resolves to do so. And any and all regulations and directives issued in terms of the state of disaster must be approved by the relevant legislature prior to implementation. The amendments will therefore create proportionally limited powers for the minister and executive, ensuring through proper procedure and legislative oversight, proper constitutionally accepted accountability of the executive. In conclusion, the Disaster Management Act's definition of a disaster is a progressive or sudden, widespread or localized natural or human-caused occurrence which causes or threatens cause, death, injury or disease, damage to property, infrastructure or the environment, or disruption of the life of a community, and is of a magnitude that exceeds the ability of those affected by the disaster to cope with its effects using their own resources. Stakeholders Committee, there's absolutely no argument to be made against the fact that government's lockdown restrictions and regulations, i.e. a human-caused occurrence, disrupted the life of communities in a magnitude that exceeded its ability, or the ability of those affected by the disaster to cope with its effects using their own resources. NIASA therefore contends that the lockdown and the regulations itself qualified as a disaster, exactly as defined in the DMA. The ruling party, in conjunction with the Minister and the National Coronavirus Command Council, took it upon themselves to decide between a humanitarian and economic crisis. And NIASA believes that, unfortunately, they failed to strike an appropriate balance. The current DMA provides the Minister with a multitude of powers, as well as the executive, to declare an extended state of
your time is up now.
Thank you very much, Chairperson. I will then just conclude by saying, sorry, in light of the number of court cases, as mentioned by the department themselves, from numerous role players in the country challenging the constitutionality and rationality, as well as the validity of the state of disaster, as well as the extension and accompanying regulations, the need for the amendment of this overreaching Disaster Management Act could not be clearer. Thank you very much for this opportunity. That is NIASA's submission. Thank you, Chairperson.
Thank you very much. We now move to the African Policy and Civilian Oversight Forum. Can we hand over to them?
Thank you very much, Honourable Chair. Thank you very much, members, for the opportunity to present at this hearing. I will be brief. We come into this discussion not as experts in disaster management, but rather we have been engaging in some of the consequences of the way in which we looked to stem the spread of C-19. Our focuses have been on issues around inappropriate use of force, the ability of the oversight community to access places of deprivation of liberty, access to policing services, policing responses, issues around assembly and deprivation of liberty. And it has, for us, identified a number of areas where certainly we think that scrutiny on the disaster management bill and the amendment bill is appropriate. And in the consideration of the motion of desirability, we would certainly encourage the committee to adopt that motion of desirability and engage the Disaster Management Act in its full extent. Our submission raises a number of areas where I think we've learned from the experience of the last 2 years, and certainly we propose that they be introduced as new areas of consideration should this bill proceed. We've all heard from the State of the Nation that the state of disaster will probably be lifted soon. We know it's been extended for another month, so we might see a change in regime from the 15th of March onwards. As I mentioned in my introduction, I think the issues that we raise are fundamental to the way in which we manage events like this going forward. And I think they need to be considered across all of these legislative regimes that might be in place. So certainly state of disaster, state of emergency. And if we shift the COVID-19 response to some other instrument, like, for example, notifiable diseases, then I think these things need to be considered within those instruments as well. I understand that this is not the role of the committee, but I simply make that point. So on the motion of desirability, certainly we do believe that the amendments will provide an opportunity for Parliament to reassert itself in the governance of states of disaster. We certainly don't believe that these review mechanisms will necessarily impact the speediness of the department to respond to emergencies. These are looking at the extensions and retrospectively. Honourable Chairperson, I would like to then just go on and mention 4 areas where I think we on, some mentioned in the bill, some not, and which we would promote to be included. First of all, in terms of definition, we are concerned that this definition remains overly broad. and accords the responsible party wide and arguably unnecessary discretionary powers. So we've recommended that all three aspects of that definition are provided, so death, injury, or disease, and serious damage to property, infrastructure, or the environment, and serious disruption of the life of the community present themselves, and then are the triggers for activating this response. We do think that catch-all phrase of other circumstances or other special circumstances should be deleted. We do believe that the disaster management legislation and any other legislation that provides for these extraordinary circumstances should also then provide for the following, and this is based on the experience of the last 2 years. Firstly, essential services. We have relied on essential services over the last 2 years. We have had debates and contestation around what constitutes an essential service and what doesn't. I think that the bill should define what is an essential service, should set out clear criteria and the process for determining whether or not you're an essential service provider and what the responsibilities are then in terms of being an essential service provider. Then we also have seen that the impact of COVID-19 and our response to stemming the spread of the virus has impacted different communities in different ways, and that this has been disproportionate depending on who you are and where you are. And I think this has been mentioned by everyone. I do believe that this needs to be taken into consideration by the department, and we think that within the bill, we should provide for the need to conduct a needs assessment that will determine the action going forward. Importantly, from our perspective, that a needs assessment must be guided by principles of openness, transparency, inclusivity, non-discrimination. We must recognize the different context dynamics within communities. We must identify issues around limited abilities and capacities in key areas, emerging concerns and trends, determine appropriate measures, the level of attention required, and that these responses be effective, inclusive, and holistic in terms of what we see. We can't afford to have the unforeseen consequences, such as we have seen, for example, restricted access to policing responses when interaction with the police happens to be in terms of physical engagement. You don't have the telephone or the airtime to be able to call on the police to help. So we need to be holistic in those responses, understand what the consequences are, and be able to provide for those consequences to the best of our ability. And that the design and delivery of any response plan must obviously be evidence-based, as we have seen, but, and we'd like to emphasize, be human rights compliant and sensitive to the socio-economic context. We understand that constitutional law, international human rights frameworks, that some human rights may be subject to limitation during states of emergency. But we are concerned that the Act does not clearly stipulate the principles and provide the guidance on those rights and freedoms which are non-derogable during any state of disaster or state of emergency. And we would insist that those non-derogable rights be clearly identified within the framework of the legislation. The legislation itself, the regulations that may accompany this, but explicitly articulate which basic human rights and freedoms cannot be limited during a state of disaster, provide guidance on the nature of rights and freedoms that are available for limitation, and that the responsible parties be obliged to provide clear and regular reporting and explanation on the human rights impact of measures adopted to manage any state of disaster, emergency, etc. Which brings me to our final point, which is on access to information. And we propose that the disaster management legislation should simplify the process of access to critical information and provide a positive obligation on the state to provide timely, accurate, accessible information relating to the disaster. So in conclusion, we believe our responses must resonate with the following, resonate with the following, I should say. That there must be open parliamentary scrutiny of the executive response, that there must be independent review of these public health directions, that there must be transparent human rights compatibility assessments, that there should be strong safeguards around powers, and particularly policing powers as our specific area of interest. And also we think that we must be very mindful of safeguards around the protection of data, particularly as we've seen sort of a huge increase in surveillance and medical surveillance areas, particularly as we've been trying to manage C-19. Chairperson, thank you very much for the opportunity. That concludes my presentation.
Chairperson.
What is happening now? Hello?
We can hear you, Chair. You can proceed.
Oh, the gentleman has given up or has finished. Okay, can we now call on the Council of Charismatic Churches?
Okay. Good morning, Chairperson and members of the Portfolio Committee. And we really appreciate the COCC to be afforded this opportunity to make a submission before the committee. And I believe that you do have, our submission there with you. So in the interest of time, I just wanted to zoom, I will just nibble on that document, some of the points. And so one thing, that we endorse this amendment bill is because we felt as the religious sector, that there's been so much abuse of power, and then that is based on the incompetence of the ministry regarding religious sector, because we, in all our engagement, even from the province of Gauteng and so forth, one thing that has been a major thing has been incompetence on religious matters. If we recall well, that the benchmark that has been used, against especially the religious sector was an incident that happened in our country in Bloemfontein. And now and then Bloemfontein has been coming, as a way to say, shut up, because you remember what happened at Bloemfontein. So as if we have no say, we have nothing to say. And then we should always remember Bloemfontein. And now, based on that time in March 2020, when lockdown, nobody knew in every sector what was happening, how to handle it. We considered as the religious sector to say, okay, let's give government chance, so that in the interest of securing health services, as they told us, was the reason behind the declaration of the disaster management. Therefore, we considered, and even to an extent, that issues like our Good Fridays, and our religious observances those time we were more than willing to comply with, you know, the request that was put before us. But with time as it unfolds, we got to learn. And then, you know, even through the very executive, that there are measures that, you know, that those non-pharmaceutical measures that could be applied and used so that we can curb, in the words of both the minister and the president, curb the spread of the virus. And we were given those short, you know, you're putting on masks, you're sanitizing, your social distancing, and so forth. And then and with time, those regulations, you know, they got dropped, you know, until we got to level 3. I remember somewhere in May, where now as the sector we approached firstly Gauteng province after we were invited to put our case across. And one of those questions we raised at COCC was, now, having given these non-pharmaceutical measures to curb the spread of this virus, then okay, we are okay. We understand that, and hence, you know, things like going to malls and to shop, look for food, you know, and places of work were open. So our logic was, by the way, if there's an individual who is hungry during that disaster, you know, going to stores and then applying those non-pharmaceutical measures to look for food, come back okay, and the very person goes to work to say, okay, let me go and look for the money and, you know, to for the food, then the person is okayed according to the regulations. What is it when the very person goes to church and apply the same measures? What's the argument there? And province promised to escalate the matter to the NCCC to say, and this is why, you know, the religious sector was reopened in June of 2020. And one of the things that happened is that the minister, you know, and the, you know, our late minister in the presidency were part of the people that were crusading and justifying why the Bloemfontein incident should not be used, you know, as a benchmark against the religious sector. And we said, we make a promise that you will not see this kind of a thing. And one of the things that we did, you know, in that understanding was that to employ the expertise of, you know, people who are, you know, proficient and excellent in quality management system, where we converted, you know, those regulations at that time in May, June, you know, into a quality management system on how to process people from how they come in, sit in our churches, and also exit. And after we have done that, you know, we said to the pastors and the leaders to say, guys, now that we have this kind of system that was informed by the expertise of, you know, medical inputs and, you know, even, you know, excellent people, to make sure that we play by the book. And we were okay. And we were fine by it. And from that point, especially in the Gauteng province, we had meeting with the PCCC of the province from that time until somewhere September. And as we got to that place until September, and from time to time, we've been consulting, asking province, the Gauteng province, to say, how is the church doing? And the church, and then the response from government in the province has been, the church is doing good. In fact, it's a good example. I remember one of the MECs, MEC Ralhogo, said, we have even gone to an extent that we also, you know, rebuke other sectors on the grounds of what happened, you know, in the church. And one other thing regarding that is other sectors copied, you know, our model. They benchmarked their reopening on what has happened with the religious sector. That if the religious sector was reopened, what was the logic behind that sector reopened when businesses and others like cinemas cannot reopen? We can use the same model to reopen other sectors, and thus other sectors were reopened, only to find a shock on December the same year, where other sectors are allowed. And now the religious sector is locked down. And then the logic was, okay, it's singing. And that singing was dealt with in May. And the minister was there where singing was dealt with. And the president said, it's about singing. Singing spread this thing. And we were shocked to say singing. And the next thing, come 2021, during Good Friday, the president is asking for a song. The, at the former, the late Winnie Mandela, our mother of the nation, there is asking for a song. And it startled us to say, okay, if COVID is spread through singing, and singing, we are told, is scientifically proven, why is the president asking for a song? The other thing was, okay, fine. Why is it, the president also promised 2 cows, at that place, because the late Mama Winnie was providing that cow in that church for Good Friday celebration and so on. And regulation said, don't eat. After church, you go. So what were the cows for? So in principle, basically, we don't trust, the executive, to handle this kind of things, because they've been irregular. They've been irregular in this, and then the sector has suffered brutally in their hands, and because they are not competent in this. And it was worse last year, during the session of the portfolio committee, where now one of the things I raised with the minister was concerning Section 6 of the very primary Act of Disaster Management Act, where I said, but Section 6 says, Minister, consult, and there are measures there, on how to handle that. And her response to me says, but Pastor Nkosi, we are not working with Section 6, but Section 27, as if now we pick what we want from the law so that we suit a particular narrative. And then as for the evidence that churches are a super spreader, is based on the assumption of Bloemfontein. And, the evidence that we provided, that province was sure of, and it has been proven, even confirmed by Deputy Minister Babela last year in this portfolio on the 17th of June, was the churches, the religious sector is doing a good job in terms of handling this. So now and then, when they are penalized for not observing, attending and so on, it was irrational. So we have a problem of competence. And then there's no evidence. If there's a evidence to say churches are super spreader, except the Bloemfontein, assumption, incident. It was so uncalled for also to hear Cooperative Ministry still referencing Bloemfontein as their way to say, hence, this is why we take decisions against the religious sector. Something that was dealt in May, that was defended by the same ministry in May when the regulations were made. Now, last year, they were so assaulting when coming to the portfolio committee to say, but no, because of Bloemfontein. And then Bloemfontein says, that's why church is super spread. It's based on a rumor of what has happened in Bloemfontein, a rumor of what happened in Korea, not evidence to say we've been to churches, we have seen what is happening and so on, and then this is what is happening, and so it's rumors. So if there's evidence, we are to challenge, the ministry to say, give us in black and white to say, you went to church 1, 2, 3, this is what you found, this is what has happened, and so on, and account. And if those things happen in church, why did Deputy Minister Babela say churches are good? Where does he get that from? And secondly, why did the province say churches are doing? Where did they get that from? Even last year with the national, where we were engaging with the deputy president, the Minister of Health said it, that, okay, but we understand you can manage within, churches and so on is fine, but what about before and after? Something that we're dealt old. So we are dealt with as a sector based on assumptions. And therefore, we are calling forth Parliament to take its responsibility, because we believe that all these 3 legs of state exist for the citizens, not for themselves. And we cannot say the courts are saying this, because with the courts is the same thing. There's a problem of competence on religious matters. Our judges need education.
You are left with 2 minutes.
Thank you, sir. Thank you. You know, our judges have an issue of competence, like the case that was raised last year, you know, prior to when we were querying why the churches were closed in December. Then all of a sudden, magically, just prior to the issue, then they amended without reasons. They amended the issue so to avoid the court on the following day and so forth, only to disqualify that case in November to say, but this is a moot case and so forth and so forth. But primarily, we need, you know, Parliament to do what Parliament is meant to do according to Section 42. That it should speak for the people. The people cannot be governed without their consent. And the people, Parliament represent the people. We cannot be governed without our consent. Thank you.
Thank you very much. We will now call on Salga to make a presentation. Salga.
Good morning, Honorable Chair, and good morning, Minister, as well as honorable members. My name is Dora Marema, and I represent the South African Local Government Association. I am in this session with my colleague, Mr. Tsepo Mohlale, who is the specialist for disaster risk management and fire services at SALGA, and he will be sharing with the committee our submission, which is very much have been compiled within the context of local government itself. With your permission, Chair, can I ask Mr. Mohlale to share the presentation?
Yes, please.
Thank you.
Yes, what is happening now?
Mr. Mohlale, we can hear you. Can you proceed?
We can't hear him.
All right. Am I audible now?
Yes, you're audible. Please go ahead.
Okay. Thank you, Chairperson, for offering us this opportunity. In this submission, I will just give a highlight in terms of the introduction and the purpose, a rational situation analysis, municipalities survey findings, and then give SALGA's recommendations into the amendment bill. Following a request for submissions to both interested parties and stakeholders on the amendment of the disaster management bill, SALGA made a written submission to the Portfolio Committee on Cooperative Governance and Traditional Affairs on this disaster management amendment bill, Bill B2 of 2001, as part of formalizing its submission. SALGA also took the initiative to seek views and contributions from municipalities on the proposed measures in the disaster management amendment bill to ensure that it reflects a local government perspective. The purpose of this presentation is to provide a local government position on the disaster management amendment bill, Bill B2 2002. Now, in terms of the rationale is the rationale to the bill is to amend the Disaster Management Act in order to amend the duration of the state of disaster. The bill further seeks to provide that only National Assembly, a provincial legislature, or a municipal council may resolve to extend a declaration of national, provincial, or local state of disaster, respectively. The bill also provides for the requisite majorities required in the National Assembly, the provincial legislature, and municipal council in order to extend a national, provincial, or local state of disaster, respectively. Now, in terms of the situation analysis, from the analysis on how this bill impacts various sectors, specifically to the local government, when we read clause 5, which amends section 55 to provide that a local government, a local state of disaster may be effective only prospectively and for not more than 21 days unless a municipal council resolves to extend it. It also provides that a council may terminate a local state of disaster before it lapses. The clause further sets out how a council may extend a local state of disaster. Clause 6 inserts clause 55A into the Act. This clause provides for the lapsing of a local state of disaster. The clause further regulates the validity of anything done under or by virtue of any bylaw or direction during the time from the declaration of the local state of disaster until the time it lapses. Now, looking at the survey findings when we had to conduct interviews with municipalities on how this bill is going to impact on their day-to-day operations in terms of the strategic focal areas as local government. SAGA's interpretation of the survey from the municipalities in relation to Section 55 of the Disaster Management Act, Clause 5, which seeks to amend Section 55 of the Act by providing inter alia that a local state of disaster may be effective only prospectively and for no more than 21 days unless the council resolves otherwise. A council may terminate a local state of disaster before it lapses. Further to that, a council may extend a local state of disaster. Now, according to the data collected from municipalities interviewed during the survey, this amendment is not supported as it modifies the responsibility to extend a local state of disaster and modifies developments of bylaws and directions. When we also look at now in terms of the preference on the duration from the local state of disaster declaration as legislated in the current act, in terms of now the proposed measures to amend it to 21 days duration, this amendment may affect rapid response mechanisms and efficiency moves to the act when council is on recess. The negative cost implications associated with the Gazette publications, procedures on extensions for local government disaster declaration status in municipalities also has an impact. Now, we also have feedback from one of the prominent metropolitan municipalities that we also interviewed that have also highlighted the incredible cost associated with cumulative gazetting and publications. Monthly extensions after 21 days will be exorbitant on municipal fiscal arrangements. And the potential challenge, lack of effective response when a mayoral committee or council is on recess, is amongst the issues that we also raised in such cases. And this also is just based on a case study presented by one of the municipalities who were forming part of the survey. Now, also looking at clause 6, of which clause 6 seeks to insert section 55A into the act by providing inter alia for bylaws or direction to cease to be of force once the local state of disaster lapses, the validity of anything that is done under or by virtue of any of the regulations or direction from the time of the declaration of the local state of disaster to the time it lapses. So based on the responses from the survey, municipalities are not in support of the proposed amendments in conjunction with Clause 2 and Clause 4 as applicable for the local sphere of government. From the local government perspective, a municipal council reserves the right and is adequately authorized in terms of the Municipal Systems Act 32 of 2002 and the Disaster Management Act 57 of 2002. This is under Section 55 and Section 27 and 41, respectively, to make regulations, bylaws, and directions. So SALGA's recommendation following the surveys and to get the position from municipalities, SALGA's recommendation to the Portfolio Committee on COPTA is one, to note the views expressed by municipalities in response to the Disaster Management Amendment Bill, B2 of 2021. It's also recommended that the Portfolio Committee note that Clause 6 of the Disaster Management Amendment Bill will have a negative impact on the ability of local government to manage local state of disaster declarations. So, Chair, in conclusion, this is the position that SALGA is taking currently, not supporting the amendment bill. Thank you, Chair.
Thank you very much. We now call the last party, Sakelika. I might pronounce you wrongly. There's something that has been put there. Mr. Tian Alberts would speak on behalf of this body, Sakelika.
Thank you, Chair. Can everyone see me?
Yes, we can see you.
Thanks, Chair. Thank you for the opportunity to make submissions today. SAKELIGA is a business group and a public benefit organization with more than 12,000 members in various industries and enterprises from small to big in South Africa. And we promote a favorable business environment for our members and in the public interest by means of support for the free market system and for a sound constitutional order. I'm Tian Alberts and I work in the legal department of SAKELIGA. Now, SAKELIGA was at the forefront of advocacy for more proportionate measures to handling COVID-19 from the beginning of lockdown last year. And by more proportionate, I also mean more proportionate to the legally challenged and draconian measures that we've seen published and promulgated under the current Disaster Management Act. And this is part of the reason why we're here today, because we think that we are in a favorable position to submit this comment. Now, in short, SAKELIGA supports the proposed amendment to the Disaster Management Act. And we've also previously provided commentary on previous occasions to proposed amendments of the bill. And the reason why we do this is the present situation where a state of disaster can simply be extended indefinitely without any parliamentary oversight, control, or opportunity for effective public challenge is untenable and it must end. And for these reasons, we specifically support the following proposed amendments. Firstly, the requirement that the extensions of the national state of disaster or a state of disaster must be placed under the authority of the National Assembly. Now, the way the Act is currently framed and implemented ostensibly makes provision for mindless extensions of the state of disaster, in this case, the national state of disaster by the minister, without any recourse to any considerations outside those propounded by members of cabinets. Now, what this means is that the cabinet or the minister can, at a whim, decide to implement a mandatory risk management control program for the whole country without compliance with the principle of the rule of law, which is what SAKELIGA is interested in. What is more, the fact that there's no oversight over these extensions makes Section 27.5 of the Act entirely deficient. This is not merely academic, because what we've seen 2 days ago is another extension of the national state of disaster without any recourse to considerations outside of those that have been expressed by members of cabinet. The second amendment that we support is that the National Assembly should be in a position to reject any regulations or measures or directions issued under the DMA. Why? Because what we've seen over the last 2 years is that a centralized authority, the minister or the cabinet, as she contends, in Pretoria can make very intrusive rules for thousands of businesses and millions of people countrywide without necessarily the knowledge of what a proper risk response would be for specific individuals and businesses. And so what we see here is that the complexity of a knowledge problem, of a central authority not having the requisite knowledge to manage risks on behalf of 60 million people, has not been taken account in the Act. And Sakeliga submits that the powers conferred to the minister in Section 27.2 of the Act should be subject to National Assembly veto. And the reason for this, one of the reasons for this, is that those powers are akin to those under a national state of emergency. The minister or the cabinet shouldn't be in a position to exercise powers through regulations that they otherwise would not have been able to done under a state of emergency according or in terms of the Constitution. Now, our experience over the last 2 years in South Africa paints a very clear picture of why these amendments are necessary. During the current state of disaster, the government's measures specifically destroyed countless jobs, businesses, and livelihoods. And evidently, also ironically, public health initiatives and risk management in terms of other health priorities were completely neglected. Now, for these reasons, we as Sakeliga also propose our own amendments to the Act. One of them is the legal requirement of strict necessity should apply to many of the powers conferred in the DMA. Currently, the standard imposed by the DMA is a necessity. So if it's necessary for the minister to do X, Y, and Z, he or she may do so. Now, that has proven to be an entirely deficient standard. If we look at it, the power to regulate the movement of people, to prevent children from visiting elderly parents or businesses from remaining open, to be able to pay employees and to actually maintain an existence. The powers to prevent those occurrences should be subject to strict necessity. And this means that it must be necessary beyond reasonable doubt that the exercise of these powers are necessary to save lives on a big scale. And this is not the standard of necessity as it currently is in the Act, sets the bar pretty low for when the minister can exercise very intrusive powers in terms of millions of people. So this is simply untenable. Sakeliga also submits that in the case where state of disaster is to be extended, in this case a national state of disaster, that there should be a reconsideration by the National Disaster Management Center of the classification of the disaster. So in other words, before the minister or the cabinet can extend the national state of disaster, the Disaster Management Center, who issued the original classification as a disaster in order for the state of disaster to be declared, should reclassify this. Because what the Act currently requires before the minister can declare a national state of disaster is that there must objectively exist a disaster and a national disaster. And this determination is done by the National Disaster Management Center. So in other words, if there's no national disaster as decided by or as indicated by the Disaster Management Center, the minister cannot issue or cannot declare a national state of disaster. This should also be the case with any extensions of the state of disaster. We don't know why this is not an outright requirement for an extension under Section 27.5 of the Act. It certainly should be. Else the minister can simply extend the state of disaster simply because there is currently one in place. And this is exactly what is happening at the moment. Another requirement or amendment that SAKLIGA submits or proposes is that the court is a statutory requirement that the court should not defer to the executive discretion when a DMA regulation is challenged. And they should bring to bear a full legal analysis and consideration of all the conduct or regulations in question, particularly when it places severe limitations on rights and causes social disruption. What we've seen in cases recently is that there isn't a full consideration of all the circumstances and arguments put forward by the parties. And an amendment in the Disaster Management Act requiring such consideration by the courts could really go a long way. Now, another amendment that SAKLIGA is interested in seeing on the books is that a full socio-economic impact analysis should be performed when a state of disaster is extended. As mentioned previously, currently there is no requirement for any substantive consideration of socio-economic impact on extension of a state of disaster. So that takes the ability to extend a national state of disaster outside of the sphere of the rule of law, where there are specific requirements that must be met in law before something as draconian as the state of disasters that we've seen or the extensions thereof can be done. So in a nutshell and in summation, SAKLIGA is interested in seeing that a more decentralized approach to risk management, better oversight, and removing the minister's ability or the cabinet's ability, or at least to temper that, the ability to simply extend a state of disaster and to bring that within the confines of the rule of law. SAKLIGA's proposals are directed at bringing government's conduct generally in line with the promise of constitutionalism, the Constitution, and the rule of law. And I must mention, and I will conclude with this remark, that it is especially in situations of crisis where popular opinion might favor government powers or interventions unbridled by legal control, especially in times like these, that strict insistence on adherence to principles of limited state power are imperative. Thank you, Chair.
Thank you very much. That actually ends the presentation by the various stakeholders. Now is the opportunity for members. Maybe let me use the term engage and not say clarity-seeking questions. I will take the hands as I see them coming up. If there are any hands, I see Honorable Kayaza, you are number one. I see Honorable Director number two. Let me take those hands for now. Honorable Kayaza.
No, thank you very much, Chairperson, for the opportunity. I think that we've heard the stakeholders in terms of what their position is. we heard the minister talking about different ministries that are sitting at National Executive and National Central Command Team and Presidential C Committee. And on questions pertaining to reality of what happens on the ground and what happens on decision making in terms of bringing security, over securitize our communities. Really, I will pursue that whether on written replies or any other forms, Chairperson. But I'm quite still to be clarified in terms of the Agri-SA, what has prompted the proposed amendments, because in many instances, children are not at school now. And if you go to the ground anywhere across the province, farm children are not going to school as a result of the ruined roads, if you like, and unusable roads by school transport. And what is the action that they have taken together with the National Disaster Management Center to assure that this doesn't happen, you know? Because I think that there are also custodians of those roads, and many transports that are coming from their areas actually do contribute in ruining those roads and resultant non-schooling of farm children. And apart from the fact that the farm workers are often terrified of the landowners who are either evicting them. I mean, Chair, since 1994 and 2004, 1 million farmers were evicted and so on. So I just want to understand what is the course of action there. Yes, and also what prompted their proposed amendments, really. And then in terms of bans on alcohol, that was presented by NISA here and so forth. I think that we are a nation of drunkards, you know, Chair. You will see a tavern everywhere, and I think that it helped us, this thing, because people are doing that out of escaping from the realities to face what the real enemy is here. And I think that the lockdown period actually brought our sober minds by restricting alcohol, so that we can then shape our way in terms of understanding where we are without escaping. So I welcome that. I wish that it could have been restricted up until now. And I'm not sure if the concern about unemployment then holds from NISA, because unemployment is not it was there before lockdown. 2013, States SA releases a quarter labor force survey. It says that 25.2%, meaning that 4.6 million of people that are able to work and are looking for work were not able to find work. So I don't know if they can clarify me on that, whether that was the first time people lose jobs, and what is their concern about that, because they also fight in another sorry, Chair, for stammering, the article that they fight with COSATU and other formations like NUMSA and SAFTU. They are celebrating that hey, people are not have not adhered to the unions, and now here they are talking about unemployment, and they talk passionately about it. That happens during COVID-19 lockdown. And whereas there is this article that they went on in public celebrating how people didn't adhere and the expiry of those formations towards confidence of the workers. So I want to be clarified, how genuine is this concern? And in terms of SALCA, maybe SALCA can really clarify on the matters pertaining to the emergency services and so on. But it's not questions that I would want to ask for now. They are not relevant to this amendment bill. And I think that that sums up my reaction, Chairperson. I don't think I have anything else. Thank you very much.
Thank you, Honorable Director.
Thank you, Chair. Greetings to the honorable members and our guests. Chair, we understand that you are operating under the new normal, where things are not normal and sometimes it's frustrating. And in that situation, the government was faced with uncertainties and the government has to act on that uncertainties. And in that process, we had the good or the positive and the negative side of what the government has done. However, in that situation, the government had to strike balance between the life and the livelihood of our people. And in doing so, some of our constitutional rights were then had to be regulated more further in order to cater for the disaster that happened. And Chair, when we speak about this disaster, we must not only confine the disaster to this one of COVID, because disaster can happen at any time, at anywhere, in different ways. And Chair, when you look now, the disaster is not a man-made, it's not planned. It's something that happens, and when it happens, there's a need for an urgent act on the matter. So hence, in our constitution, we have a provision that is guiding us, who is responsible, that is guiding us on who is responsible for what, when, and how. And so far, South Africa is one of the countries that have managed this COVID disaster very well, because we had all necessary tools in place in order to deal with the disaster in the country. Our constitution, our structures that were in place. We managed to deal with this disaster to a point where, even if you can check our death toll in terms of COVID, as much as it's around 100,000, but it's much lesser compared to other countries. And Chair, when you look at this proposed bill, I think I have some concerns. I think that it does not provide the solutions to our challenges, but it serves to create confusion and more challenges. And in that way, it's over-regulating what we already have, which is a problem. When you look at the challenges of local government, it's because when there are issues that need to be addressed, we want to address those issues through the laws. And we end up having so many laws that are there in one entity. And at the end of the day, we are unable to address all those laws as they are. And then Ms. Rona Becker, if I'm right, from National Employment Association of South Africa, you spoke about oversight, of which I agree with you. Oversight is very crucial and already, however, it's already happening. The Portfolio Committee has played its oversight during the beginning of COVID. Until to date, we are still playing our oversight. That is why all the provincial government were called, different municipalities were called, and then we even dealt with issues where there were elements of corruption. We referred the matter to SIU. And then on the issue of the collapsed economy, we agree, as the government has introduced measures to assist on uplifting the economy and assisting the SMMEs that have suffered a loss during this time of the disaster. So I would like to understand, when you are speaking, emphasizing more about economy, at whose interest? Because remember, our government is a caring government. As much as we are frustrated by the issue of collapsing economy, we also need to strike balance between the life and the livelihood. Remember, if people die today, you cannot replace their lives. But if a particular store is affected by COVID, we can still rebuild that a particular store. And then on that Nkosi, we noted your concerns as the religious sectors regarding this process. And unfortunately, government had to take unpopular decisions because the situation was uncertain at that time. At that time, there was no lot of information regarding the issue of COVID and stuff like that. The scientists were busy trying to find out and establish how do we deal with this matter. But as time goes by, when government got more information regarding the COVID, the regulations were then made in a way that it accommodates each and every situation as the information was coming. So, and we also note your concern about the Bloemfontein reference, and we'll take that up with the department, because I understand that it was an incident that happened and no one predicted that such thing will happen. However, there's that thing that it happened, but it can't be that every time when you raise issues, you are then referred to that one. We will also follow it up with the department. And you also raised the issue that you don't trust the executive, you don't trust the court. And the question is, who are you trusting? And when you look at this bill, they are saying that the state of the disaster to be extended, the parliament, if it is in a national level, the parliament must sit. We have our schedules as the parliamentarian. If a disaster happens now at 10 o'clock in the evening, and there's a need to act at 10 o'clock, do we have to leave it as it is and wait for the following day or the other day where members will be available so that we can sit and discuss the disaster? No, it cannot be. It's going to be time consuming, it's going to delay the process, and that thing on its own is going to make our government to collapse. We've got necessary tools in place. What we need to do is to strengthen oversight. And when you speak about public participation, every clause in the constitution, there was a public participation. When you look at the disaster management laws and everything, there was a public participation. So we can't say the public were not involved in the process. So that's my input, Chair. Thank you.
Thank you very much. Let me first say thank you to our guests, the stakeholders, for the presentations. And we're still engaging with this bill. And I think we'll still find time as the committee to sit down, look at some of the presentations you have made and your comments. So in other words, as members of parliament who are supposed to represent you, this time we have allowed you to come in and speak on behalf of your membership. So we have taken note of those issues that you have raised. Yes, the department was here as well to indicate, as the executive led by the minister, as people who execute the laws that have been passed by Parliament. One of them, the one that we want to amend, and we will now allow yourselves, if there's anything from the different stakeholders out of the comments that were made by members, if there's anything you want to talk to, I will look at your hands and take them as they come. I see Mr. Nkosi, you are number one. I see Mr. Obecker as number two, and Kamfa number three. Can I take those hands in that order? Just comments now on what has been raised. We're no longer asking for presentations.
Okay.
Thanks.
Thank you, Honorable Chairperson. It's interesting, what I hear Honorable Direko was pointing to on the issue of trust. Now, the way she puts it, it's not exactly how I imply it. So let me put context to what I'm saying. Now, the issue there of trust is saying, now, when your voice is silenced, then things are done in your name or for your name without your involvement. Then how do you trust? Because of we've tried to say, let's speak to the ministry. Then we are not receiving the kind of attention that we wanted to get. You know, in most cases, even the Gauteng province was doing a better job than, you know, your national department where this management of this thing was concerned. So if the executive doesn't want to listen to the people they claim to be serving, then who do you run to? And what one of the gaps I've seen is the issue of competence. You are clueless. You know, I mean, the ministry is clueless on matters of the religious sector and so on. It's dealing with the sector based on assumptions. We assume we know. We assume this happened at Bloemfontein. We assume, okay, scientists are saying this. Even the very scientists, they don't have evidence to say this has happened in churches. This is what we've seen. I dare them to bring it. Okay, sorry. And then secondly, let me deal with the second one quickly, Chairperson. Let me not abuse privilege. And the second thing is the issue of participation. She's saying public participation. Who decided to choose that churches should be closed on when the president closed on December 2020? Was it the religious sector, or was it willy-nilly? And what evidence was used? Because the issue of
we have
sin,
had you, Mr. Nkosi.
the issue of sin is pointless.
No, let's not sing now.
Yeah.
I think we have had you. Can we
Thank
move
you,
to the next speaker? Honorable Becker.
Thank you very much, Chairperson. I just want to clarify on the matters that were addressed to NIASA and to myself. I want to confirm that NIASA fully understands the extremely difficult task that the government had in mitigating the COVID-19 predicament and curbing the infection rates and deaths, creating capacity in the health sector and protecting lives and jobs. The problem is the regulations and the lockdown levels and the restrictions and directives that they issued through their extensive power as given to them through the Disaster Management Act as is, was disproportionate. It set out to achieve a certain purpose, which it did not. It was more harmful to the economy, and that's why, yes, unemployment existed before the lockdown, but it exacerbated our unemployment figures because people weren't allowed to work, people weren't allowed to fulfill their entrepreneurial dreams and needs and such. So, and apart from that, the support received from a government, from SMEs, I mean, the fraud is still coming out. You know, it wasn't granted to all SMEs in need. It was very nitpicky from government side. And we have, I mean, proof from employers that came to us and asked for aid and help and why they're not getting the support from the government. So we understand it, but we do support the passing of this amendment bill in order to ensure proper legislative oversight, proper participation in directives and such, should such a disaster ever hit our country again. Thank you very much, Chairperson.
Kamfa.
Thank you, Chairperson. Just in regard to the question that was raised towards Agri-SA, road infrastructure was severely damaged even before the disaster that we're currently facing with the heavy rainfall and torrential rains and storms and hail. So Agri-SA is of the opinion that even though that the sector is severely affected, the agricultural sector, road infrastructure, it's also a cross-function between other departments as well. We're also liaising with the National Disaster Management Centre through the National Coordination Committee, and therefore we also suggest that a period of 21 days for a national disaster is not sufficient. we are still busy with impact assessments on grassroots level throughout South Africa to get a list of all the roads that's being affected, because it does not only affect, like the honourable member said, children, farm workers as well being transported to work. Farmers need good infrastructure to get their produce to markets, harbour infrastructure, etc. So there is a bigger problem. We are trying our best to obtain all this information so that we can place the National Disaster Management Centre in a position to reprioritise money for road infrastructure to be repaired in cooperation with other sector departments as well. So thank you for that.
Thank you. Albert.
Thank you, Chairperson. I've listened to Mrs. Tereko's comments or response, and she mentioned that government has a tough job to strike a balance between saving lives and livelihoods, and also that the government is a caring government. Now, the response assumes that government must be in the business of managing risk on behalf of everyone in the country, which isn't a given. This is not something that's in the bag, that government should be in the business of managing these risks and supplanting the discretion of individuals and businesses to manage risk as they see fit, given the circumstances known to them, to supplant that by the discretion of the minister. And that is why these amendments to the Act are so necessary and crucial, because the government shouldn't have the power or shouldn't bear the burden either of managing the risk on behalf of millions of people and businesses. These amendments are necessary so that the government can only intervene when it's strictly necessary to do so. And that brings me to the current circumstance where we are currently still in a state of disaster, which has been extended 2 days ago, which assumes that the government should be mitigating, managing, and almost acting on almost taking a delegation from people of the country to manage risks on their behalf, on the assumption that they can't do it on their own. But there's nothing in reality that points to this and points to the need for government to do this at this very moment. And this is why these proposed amendments are very actually relevant at the moment, and they're very current. So just again, Sakeliga supports these proposed amendments.
Thank you. Well, now, because we are almost about to close, we'll now allow the minister and Tim to also comment, because our guests, whilst they are speaking to us as a committee, they are speaking to government. Well, the minister did indicate she might have connection problems. If the leader of the delegation from the department can say something, if the minister is not there, and once the minister comes in before we close, we must allow her.
Maybe I should start.
Oh, you are already okay.
Yeah, because
Yeah.
at this point I've pulled off. I've pulled off so that I have a connection. Thank you very much. I listened to most of the stakeholders. I just want to respond to a few. First, I want to just say that the religious leaders were met many times. The first stakeholder to be met, even before the lockdown, was the religious sector at the guest house. And government was led by the president himself in that meeting. And after that, we had several meetings. Sometimes we met them alone as Cooperative. Sometimes we met them led by Minister in the presidency. And many times the president led those consultations as we were moving along. And sometimes then there would be disputes even amongst the religious leaders about why these ones are representing and the others, and the presidency tried to change the database of people who are being consulted. But the religious leaders were consulted many times. Secondly, I want to say, when I mentioned Bloemfontein, it wasn't in my input. I was responding to a very specific question. We don't mention Bloemfontein all the time. I was just responding to a specific input that said the decisions that were taken around the religious gatherings. And I did not say that's the only thing that informed us. So we don't use it all the time. We won't use it all the time. It was just because it was a very specific question. I then want to come to the issue of business. Maybe before coming to the issue of business, let me say that government also had to learn from the Spanish flu. The Spanish flu engulfed the world, and the world lost about 3 to 4% of its population. But in South Africa, things were not handled properly, especially the issue around quarantining and so on. And that's why in South Africa lost 6% of its population within a very short space of time. As I said, there was Black October, where hundreds and hundreds and thousands of people died because the government had not been proactive and had not taken the measures that should have been taken. Now, if you lose 6% of your population, do you think the economy survives? The economy will not survive if we had lost 6% of our population through COVID. Because the people who drive the economy would have died. So I think when we look at this, we must look at it in its totality. So the government this time had to be very proactive so that we save both the livelihoods, but also the lives. Because it's not so much the restrictions that would have destroyed the economy. If we had allowed a situation where hundreds of thousands die in this country, the economy would have gone down without the restrictions. But also, we are talking as though we live in an island. The economy of South Africa is very linked to the economies of the world. When at times our restrictions were not as high as the world thought, they red listed us. They stopped flights coming to South Africa and stopped South Africans going to those countries. So we shouldn't act as though we're just in an island. Everything that happened in this country is because of what was happening within the borders of South Africa. It's influenced by what happens outside. And at times, our economy was restricted not by us, by other countries red listing us and not allowing travel. If planes are not allowed to move, cargo that is supposed to be carried by those planes cannot be carried to and fro. So I just thought, as we debate this matter, we should take all those things into account and not pretend as though we're on an island. The government may not have been perfect. No government in this world was perfect in dealing with this pandemic because it's something that came unexpectedly and that had various implications. But I must say that considering, if you compare what happened during the Spanish flu and what happened here, the government has tried and has, to some measure, succeeded. Yes, the situation cannot be perfect, and I'm not saying the government is perfect. But also it is incorrect to say the government has extended the national state of disaster indefinitely. No. Every month, the cabinet has to sit and look at what is happening, get advice from health, get advice from the Net Joint, look at what's happening in the world, and then decide whether the national state of disaster is extended or not. It's never something that we just said you are extending indefinitely. And when the day comes when the government feels that we can now manage this pandemic using health regulations and other regulations, that will the national state of disaster will not be extended. So I just thought I should correct the notion that the government sat one day and said we are extending the national state of disaster indefinitely, as I heard from Sekelika saying that. Thank you, Chair.
Thank you very much, Honorable Minister. Honorable members and our guests, I think at least we have collected information. We will be different from when we started engaging, and we're still going through the process of the bill. And otherwise, thank you very much for the different inputs and the clarities and the engagement. This meeting must now end here because there are also other engagements we are going to. Otherwise, thank you very much, Minister and your team, for honoring this session and the guests who actually made presentations. So the committee will be different from when we started. The meeting is adjourned. Thank you very much.
Thank you,
Thank you,
Chairperson.
Chair.
Thank you.
Thank you.
Thank you very much, Chair.
Thank you.